Hi, good evening. Am I audible to you? Just ping in the chat box so that I could know whether my voice is audible or not. Yes, someone, so that we could start. Yes, type in chat box that my voice is audible. Okay, let us start then. If it is audible, we will start discussing the Manipur violence first, and then we'll start discuss further about these Bharatiya Nyaya Sanhita. So these are few acts which are very important from the exams perspective. Okay, you have seen that a lot of violence has occurred in Manipur. So in that perspective, I think the CLAT can ask the questions. So let us start discussing about various tribes and what are the types of tribes in Manipur are. So the first line, it reads that violence between the Manipur's Kuki tribe. Remember this name, Kuki tribe. They can ask questions like this: violence in Manipur was happening between which two tribes? So the two tribes which are important for you are these two, Kuki and Meitei. These two tribes are very important from the perspective of exam. Uh, because a lot of politics has revolved around it. So the passage, if they ask, will certainly be static in nature, and they may go for geographical reasons, the tribal reasons, what are the reasons, what they are really demanding to grant the scheduled tribe status. So that we need to dwell into. So the reasons, what are the reasons? The first reason is that Manipur was boiling since February 2023. Manipur has been restive since February, when the state government launched an eviction drive seen as targeting specific tribal group. You know, tribal identities are very much are certain in the regions. Not only in Manipur, for example, earlier there were classes in Assam as well. So if you know about the Bodoland and things in a district called Kokrazar, you have seen the violent clashes everywhere. When you talk about the culture of tribal affairs, then it becomes very sensitive issue. So same has been triggered. Even the High Court's order, Manipur High Court direction to the state government to pursue a 10-year-old recommendation to grant scheduled tribe status, that is ST status, to non-tribal Meitei community. Here, the point is what? The Manipur High Court granted the it recommended of granting status of which community? Meitei community. Remember this name. So it is the point of clash. So the court's order has brought the historical tensions. There were tensions already between these two communities, Kuki community and Meitei community. And you know what happened, how it, the events, how it turned out. Remember this name? The state is like a football stadium with the Imphal Valley representing the play field at the center and surrounding hills. The valley, which comprises about 10% of the Manipur's landmass, I'm talking about the Imphal Valley, okay, which is the capital city of Manipur, is dominated by non-tribal Meitei. Imphal is dominated by which community? It's dominated by Meitei, who account for more than 64% of the population of Manipur. They have almost 40 MLAs out of 60. You know that condition, if you have studied in polity, that you cannot have less than 40 MLA. You know that for a state legislative assembly. Only exception is what? You know that rule. Which state has maximum number of seats in state legislative assembly? That is UP. It has more than 400 seats. So why seats in state legislative assemblies are important? For the purpose of election to Rajya Sabha. So if you have your power in the state legislative assembly, it is reflected in the upper house of the parliament, that is Rajya Sabha. And for that purpose, you require Lok Sabha and Rajya Sabha support for passing a bill. It cannot be passed without the support of Rajya Sabha. That is important. Remember that. So let us move ahead. This is not so important from exams perspective, but if you need to know about this, in case if they ask passage, so they can talk about this also, about the cookie land. There are insurgencies in the state of Manipur, in the state of Nagaland. You know that the concept of Greater Nagaland. So the concept of cookie land is also there. The concept of Bodo land is also there. So you should also keep this in mind while studying the Manipur violence. In that case, it becomes important to know about the shoot at sight orders. Shoot at sight orders, you might have studied, you might have seen this term a lot of times in newspaper, that there are riots going on and police have been given shoot at sight orders. So what is that order, and which act provides that permission for the police or army personnel to shoot the people, the common man? So look at this CRPC Act 1973, which such orders may be passed under the statutory powers related to the arrest or prevention of the offences or disbanding unlawful assembly under the sections 41 to 60 and the section 149 to 154 of CRPC 1973. These sections are important. You might have heard very common this article 144. You might have heard कि 144 लग गया है, 4 लोगों से ज्यादा लोग जमा नहीं हो सकते. तो बहुत बार आप जब दंगे होते तो ये सुनते हैं. देखो आगे लाइन में लिखा भी है कि सेक्शन 144 of the CRPC enables the wide use of powers while dealing with the urgent cases of apprehended danger or annoyance through the issuance of orders. जब किसी भी सिटी में सेक्शन 144 लग जाता है, मतलब धारा 144 लग जाती है, तो 4 से ज्यादा लोग जमा नहीं हो सकते किसी भी पर्पस के लिए. यस, हाँ, कोविड में भी लगा था, जब भी दंगे होंगे, और whatever may happen, this in case of public law and order, they may use this what we say article section 144 of CRPC. Public law and order. बिल्कुल बिल्कुल. Then I think in the CLAT exam of 2022, they have asked about this Armed Force Special Power Act 1958. What it empowers? It empowers the armed forces. It is not related to the police. Okay, it is related to army. So it uses the it grants the permission to use the force in disturbed areas. So in Manipur, it has been extended. Okay, APSA. It is called as AFSA, Armed Force Special Power Act. जवाब नहीं देना पड़ता क्योंकि इसकी परमिशन है अकॉर्डिंग टू एक्ट, बट वहां पे अफसा लागू होना चाहिए. विदाउट लागू है, कश्मीर, मणिपुर, नागालैंड, ऐसे सेंसिटिव एरियाज में वेयर देयर आर चांसेस. 370 से हटाने के बाद ही लागू हुआ है? नहीं, उसके पहले से भी था. हाँ, क्योंकि एक्चुअली द पीपल हु talk about human rights, they generally are against the use of what? APSA. because that is not very democratic in nature. In democracy, you have a right to protest and all, but for the purpose of security and internal security, it is given permission to the armed forces. But its uses are very restricted, and you have to take the Ministry of Defense has to permit you. Ministry of Home Affairs has to permit you, without which you cannot use the force. Now, this is also important. India's new parliament building. India celebrated the inauguration of its new building in its 75th year, that is called as Amrut year. Okay, built by Indians. Earlier, this parliament, currently what we used to use, that parliament was built by Sir Edwin Lutyens. Remember this name, Sir Edwin Lutyens. So he is the architecture. He was the architecture of Indian Parliament. Okay, you know that the history. Earlier, our capital was Calcutta, and it was shifted from Calcutta to Delhi in 1911. Remember this. So Delhi was not a capital earlier. Earlier, the capital of British India was Calcutta, and in 1911, when we held the Delhi Darbar, the concept called Delhi Darbar. In Delhi Darbar, we have three Delhi Darbars. Kolkata and Kolkata are the same. It's not only the difference in nomenclature. Like Madras and Chennai are same. So in that manner, the Kolkata or Kolkata, like Orissa and Odisha. So this is difference of nomenclature. Even in Kerala, for example, you see Kalikat. So most of the time people call Kalikat and others call different name. Like Madras and Chennai also. Okay, like Mumbai and Bombay, names of same city. So now, for us, new building is important. Look at the structure. The structure is triangular. Yes, it is called as Central Vista project. If anyone from Hyderabad, if you are able to unmute yourself, and you need to, if you want to ask questions, you can ask questions. Okay, Vanilla and others. If you want to ask, you can ask questions. It will not disturb me. Side of the old books. Yeah, this circular is old. Rajya Sabha. This look, center is near in that campus only. The building is like this. This is the triangular in shape, and we will discuss why it is needed, how it has increased the size of Lok Sabha, and how technology has been put into the place for the MPs. So remember this name, Central Vista Redevelopment Project. That is the name of the project through which we have executed this plan. Why we needed the new parliamentary building? One is narrow sitting space for MPs and inadequate workplace. Look, we are the country of 140 people. If you look at the Aadhaar data, for example, we have issued, I think, around 141 crore Aadhaars. So it means our population is around 135, 140 crore. It is calculated. So now we will we are being using the census of 1971 for the election purpose. Remember this. The census which we are using as a census for population for the election is 1971's census. So old building was never designed to accommodate a bicameral legislature with a full-fledged democracy. What is bicameral? Bi means two. Camera means houses. So we have two houses of parliament, which are the Lok Sabha and Rajya Sabha. So the number of Lok Sabha seats are likely to increase substantially post 2026, where the freeze on total number of seats ends. As I have said, the freezing point is this 1971. After 2026, when you see currently we have something around 543 MPs, it will be increased, because then the census which will be used will not be 1971 census, but it will be 2021 census, most probably, because then 2026 is the time period which is the bridging point of uses of population census of 1971 for purpose of seats. Then next point is distressed infrastructure and absolute communication structure. So it was built in 19, let us say 19, old parliamentary building, if you look, was built around, it was, the foundation stone was laid in 1921. So look, 100 years have been passed. So you cannot say that the technology is updated there. So technology is absolutely not updated. So you need, a lot of things are involved for the purpose. So you need technology, digital structure and all. Also, you know the attack on parliament, 2001's attack. So afterwards, the safety concerns are there. We have already seen the attack in Parliament of India. Apart from inadequate workplace, safety concerns. Now look at the features of new building. It has built up area, sitting capacity. Details are not important for us. Okay. What details are important? I'm telling you. The details is this. We have 888 seats in Lok Sabha and 384 seats in Rajya Sabha. Yesterday we discussed about this. Somebody in the lecture said that the seats are 180, and then I think Havila was there who said it's 186. So now it triple it. Yes. Just tell me where is chat. Yes. Split. Yes. Thank you. I now I'm able to see your chats. Earlier I was not able to see. There are some questions. The chat work. We're here. If you are not able to talk, then you can type your messages and then we'll discuss about that. Okay, let us continue. May I continue? Okay. Apart from the number of seats, the thing which is important is the themes. One is lotus theme and another is peacock theme. These two themes are important. Okay, remember. And the questions which you have taken, we can talk about that one by one. Apart from that, you might have seen, if you are following the newspapers, the Hindu or the Express, which I have told you to follow, you might see that there is a lot of concerns regarding the national capital territory of Delhi. Might have seen a lot of times Arvind Kejriwal and the Aam Aadmi Party talking about the center is not allowing and not granting permission, this and that. You might have seen if you are following the newspaper. So look at this. The government of national capital territory of Delhi amendment ordinance. You know what is the difference between ordinance and act? This is not an act. This is an ordinance. Look, ordinance has the validity of 6 months only. Okay. Ordinance validity is 6 months. And ordinance is issued by the President of India according to Article 123. It's very easy to remember. Article 123. And it is issued by the President of India. When one of or both of the houses of parliament are not in session, then only President can issue the ordinance. Remember that. Act has a validity until it is repealed. Act has validity until it is repealed, but ordinance has validity only up till the 6 months, and it can be extended up to 6 weeks only, 6 months and 6 weeks. Remember this. So there are a lot of problems between the capital regarding the uses of power. So we will look at the center's agreement, that is arguments of the central government and the arguments of Supreme Court. Look, what center is saying that the national capital, Delhi is the national capital. Okay, it is not like any other union territories. It's not like the Puducherry or not like any other territory, because the issues of security concern are are the it is the responsibility of the government of India. So it needs to have the control over the territory. And in terms of police, for example, Delhi police acts under the control of what? Central government. So for the purpose of security, without which it will be very hard for the central government to handle the situation when the situation of law and order arises. So that's the central argument of the law and order from the center's perspective. So no union territory has power over services. Therefore, Delhi too could not exercise such power and could only legislate on issues that other union territories are explicitly allowed to. I mean, they are talking about the equality of power between amongst the different union territories. So, union territory of Delhi cannot be separately treated. That is the argument of center. Again, the legislative power of Delhi can extend an entry only when that entry is clearly and unequivocally applicable to union territories. So there should not be any ambiguity involved. That is the central's perspective. What Supreme Court is saying? Supreme Court said that Delhi has a special constitutional status under Article 398 AA, and it's sui generis, it is unique. Center was talking about the equality of different union territories, right? But here the Supreme Court is what it is saying? It is saying that it is unique. The word used is sui generis. It means it's unique in nature. It cannot be treated in collection with other. It should be treated differently and uniquely. That is the argument of Supreme Court. And what is the legal provision for it, for the Supreme Court to talk about that? It is Article 239 AA. That is the article which is Supreme Court is using. It termed the phrase, insofar as any such matter is applicable to union territory. Supreme Court is using this, and it vested the Delhi government with legislative and executive power over entry 41 about public order, police, and land. These three things are important. Okay, public order, police, and land. These three things, these three entries are important. As I have discussed about this Article 123, you can see on your screen right now. I have discussed about this Article 123 about the ordinances. And now the next act, which is very important, is the Posh Act. You can see the Posh Act, a recent investigation done by a government committee headed by Mary Com, the Mary Com, to look into allegations against the president of WFI, Wrestling Federation of India, revealed that more than half of India's 30 national sports federation don't have an internal complaint committee, that is ICC, Internal Complaints Committee, which is legal requirement under the Prevention of Sexual Harassment Act 2013. Prevention of Sexual Harassment Act, that is Posh Act of 2013. The Sexual Harassment of Women at Workplace Prevention and Prohibition and Redressal Act, which came into force in 2013, applies to all public and private. Remember this. It's not only to public. Okay, it is to public as well as private organization throughout India. So POSH Act is extended not only to the public organizations but also to private organizations. So they can ask this question because a lot of politics was involved around. There were protests in Jantar Mantar. You have seen if you are following the newspaper. Many Olympic winners were there, and a lot of things happened. So just follow that. Which act is that, and whether it is applicable to private sector or not, that is important. Then, what is ICC, Internal Complaint Committee? The Internal Complaint Committee is what? A law requires that any employer with more than 10 employees to form an ICC. ICC should be minimum of 4 members, and the box is called as C box. SHE box, she box. Okay. So they can ask, she box is related to what? The C box is related to ICC, that is Internal Complaints Committee. Again, the divorce under Article 142. Recently, a 5-judge constitutional bench of Supreme Court ruled that it can exercise its plenary power to do complete justice under Article 142, subclause A of the Constitution, to grant divorce directly without referring to the parties to family court. So article involved is Article 142A. The first question which comes to our mind is what is the current procedure for getting a divorce in India? Divorce in India is primarily governed by personal laws, which vary depending on individual's religion. Hindu Marriage Act of 1955 governs the Hindu Marriage Act, which includes Jains, Buddhist, Sikh religion, while the Muslim Personal Law, that is Shariat Act application in 1937 Act, which applies to the Muslims. Additionally, other acts such as Special Marriage Act of 1954 and Indian Divorce Act of 1869 applies to interfaith marriages. Okay, so these are the certain procedures or certain acts through which the divorce and marriages are done in India. So in 2023's paper, I think they have asked a couple of questions related to interfaith marriage. You have seen that if you have done previous years questions, then you could have got many observations. So they have a couple of times asked questions on interfaith marriages. So interfaith marriages cannot be done with the help of Hindu Marriage Act or with the Muslim Marriage Act. It requires Special Marriage Act. Remember that. And last year they had given one passage on it. So after the lecture, go and read that passage. There were a couple of questions. There were the names of couple of a different community, and they got married, and what challenges they face and what is the law regarding that. You need to go through the question and answer. The answer key is also been provided. So go through that. Flip through the question paper so that it will be helpful for you in coming exam. Majorly we deal with 3 to 4 acts. One is Hindu Marriage Act, another is Muslim, that is Shariat Act of 1937, and another is Special Powers Act. So Jains, Buddhist, and Sikhs are included in Hindu Marriage Act. They don't have different special acts. They are covered under the Hindu Marriage Act. Special Marriage Act. Yes, definitely. But they have to register in court, give 30 days notice period, And if somebody has to take this any doubts, they can take any. I mean, if in that case, uh, the court marriage is done, so that is valid proof of marriage. Other, yes, yes, yes. No, no. For intercaste, not, because intercaste is what, the caste belongs to same religion, no? So they will be doing marriage. In fact, her her faith is considered as marriage. Faith is considered as a religion. Interfaith means inter-religion. Remember this. Interfaith is not intercaste. Now, the fixing PC PNDT Act. The Delhi High Court recently highlighted the need to review the Preconception and Prenatal Diagnostic Technique Act for its effective implementation. What is the background? The background is this. The judgment came in response to a plea moved by a man seeking quashing of an affair registered against him under the PC and PNDT Act. What happened? What is PC and PNDT Act? That is Preconception and Prenatal Diagnostic Technique Act. Okay, that is the full form. It is an act of parliament to prohibit sex selection. People do this sonography, you might have seen. And if these the people, this is called as son of soil. I mean, not son of soil. This is called as the people generally want son preference over the daughter. It's very unfortunate, but this is the reality. The today's generation, and not in today's generation, but also previously also this has been done. This can be starkly seen in the studying the census of India. According to 2011 census, the sex ratio is around 920 around the national average. Okay, so it is very unfortunate and very pathetic situation of the country that talks about the culture, and when we we go for the sex selection, it's very unfortunate. It should be stopped, and the act does the same. So what happened? So it is an act of parliament to prohibit the sex selection before or after conception, or for regulation of prenatal diagnostic technique, that is sonography, for detecting the genetical abnormalities or metabolic disorders. Which is this sex selection is only allowed when, if you see, there are genetic abnormalities in the kid or the prenatal thing. So that in that case you can do abortion, but without any reason, just because the sex of a person is girl or female, so it should not be allowed. That is the purpose of PC and PNDT Act. It was first enacted in 1994, and at that time it was known as Prenatal Diagnostic Technique Act, PDTT. So afterwards it was changed to PC PNDT in 2004. What is the objective? Objective is restricting the pre-birth sex assurance and to save the girl child. There was very you might have seen this logo, Beti Bachao and Beti Padhao. You might have seen the Beti Bachao in that act is saving the girl child. Okay, and for that purpose government is giving a lot of schemes to the government, to the couples who are adopting or having the first girl. So there are not many schemes for them. Let us talk about this female foeticide. What are the causes and consequences? Patriarchal system of society is, it means that when male of that society is controlling the whole of the family without having any role of female, and this person is male. Okay, and it has very strong say, and others are very inferior. I mean, particularly women are inferior. That is patriarchal, where everything is looked upon. The head of the family is whom? Head of the family is male. So that is called as patriarchy. It is very common word in sociology. If you study sociology, the patriarchy is very common. In feminism also, the most important target of feminist movement is a patriarchal system of the society. That is what they target. Then desire of son in the family is the second cause. Then the dowry system. People think that if I have a son, and when he will get married, he will get a lot of gold and a lot of silver and money and Scorpio and whatnot. They have that kind of system in mind, so they want a son. So that the dowry system is one of the curse on our social system. It should be completely abolished. Fourth, family a fear of family lineage coming to an end. People think that family is the family lineage runs just because of son and not because of daughter, because daughter get married and then goes to other family and changes the surname. You have seen things in day-to-day life. So okay, increasing crimes against women creates fear in the mind of the parents. This is related actually the rural families, particularly not in urban areas. Although the crimes in urban areas are more, I'm not saying that crimes in urban areas are not there, but the fear in the rural area is persistent, because mostly people go for farming, and father and mother, they go for farming, and daughters are all alone in the family when they are young. So they fear that if we have daughter or more daughters, so it will be problematic for us in future. Then there is the most important cause is lack of education. That is also one of the major reason. Okay, so what has been the consequence of this? The skewed sex ratio. As I've said, the sex ratio as per 2021's census, although there is no 2021's accurate census, but it is around 943. I have said it's 920s around. Then again, this is also very important. Right against self incrimination. The Supreme Court refused to hear a plea filed by Deputy Chief Minister of Delhi. Who is the Deputy Chief Minister? Manish Sisodia. Under Article 32. In Constitution, in exercise, in an what he said, he did not seek a remedy in High Court first under the Section 182 of the CRPCC. What is Article 32? This is Dr. Ambedkar said this is the soul of the Constitution. The Article 32 is the heart and soul of the Constitution of India. It is like constitutional remedies, right to constitutional remedy. It grants the right to approach to Supreme Court for enforcement of fundamental rights. If your fundamental rights are violated, you can directly go to Supreme Court or the High Court. The Supreme Court has original jurisdiction in such. What is the meaning of original jurisdiction? The meaning of original jurisdiction is that you can directly approach to the Supreme Court. That is called as otherwise, appellate jurisdiction is there in the Supreme Court in every other case. For example, let us say right to property under Article 300A. It is a constitutional right. It is not a fundamental right. Fundamental rights are only those rights which are covered under Article 1, Article 12 to 32. That is the Part 3 of the Constitution, fundamental rights. All other rights which are in Constitution but not in fundamental rights are called a constitutional right. So constitutional rights we cannot go for enforcement of the constitutional rights to Supreme Court and High Court. We will have to go to the lower courts first, and then we can appeal. That is the difference. Remember this. So classical case is right to property. Let us say Ministry of Road Transport is building or constructing roads from my farm. So I cannot go to the Supreme Court or High Court directly just because they are creating or constructing roads under my property, because right to property is not a fundamental right. It is a constitutional right. So I will have, if in case I want to file the FIR, I will go in lower courts, okay, for petitions. What is right to self incrimination? Remember this. What is right against self incrimination? It is one of the provisions of fundamental rights under Article 20. Another article which is important is 21, but we are talking about 20. Okay, right against self incrimination. So no ex post facto law. This is very important. What is the meaning of no ex post facto law? It means that no person shall be punished after an act where a crime when it was committed. It means, for example, let us say someone stole something, and the punishment for stealing was 3 years, and he stole on, let us say, 1st of December, today's date, and we created one law on 2nd December. So that stealing will get a 5 year punishment, imprisonment. Now he has stolen the thing on, let us say, 1st December. So we cannot say that uh, you will get 5 years uh, punishment. No, punishment will be only 3 years. That it means that no ex post facto law we cannot implement previously. Okay, what is the next is no double jeopardy. It means that person cannot be punished for the same offense twice. As I have given the example of this person who is stealing. So once we have given him the punishment of 3 years, we cannot give him the punishment for the same act again. His punishment is done. Now he is free. So you cannot punish the same person for the same crime 2 times. Okay, that is called as no double jeopardy. And right against self indiscrimination. It means that no person accused of an offense shall be compelled to be witness against himself. You cannot compel a person to be witness against himself. You know this concept called witness, that is gawah, right? So the gawah should be some other person, not the person who is stealing. Okay, not the culprit itself, or culprit himself cannot be the witness to himself. So these three principles are actually are the principles of natural justice. So they can give the passage on natural justice. Okay, natural justice has been one of the most important principles in the law, in the legal arena. Okay. Now next point is digitalization of courts. The Supreme Court in February 23 introduced an experimental basis the live transcription of its proceeding using the artificial intelligence AI, that is artificial intelligence mechanism. The virtual screen live streaming for the constitutional bench hearing the Thakre Shinde dispute. Thakre Shinde dispute is a Maharashtra political crisis regarding the political party and the symbol, and the split in the party, and which faction is correct and which not. That was very important and turning point in Maharashtra's politics. And afterwards, if you know that the government fell and then new government came. So that was the case that is called as Thakre Shinde dispute. Mahavikas Agadi Sarkar. So what is e-courts project? The government of India has launched e-courts integrated mission mode project. It talks about the computerization. Okay. In the year 2006, for the first time, e-courts were launched. Okay. Remember this. And Gujarat High Court is the first court in the country to do live streaming. Remember this. If they ask in your paper, which is the first High Court to go live. Okay. Then the next point is right to be forgotten. Recently, a doctor filed a plea for enforcement of right to be forgotten, which includes removal of news articles and other indiscriminate content related to his wrongful arrest in response to fabricated FIR against him. Someone has done a fabricated FIR against him, and then there were news. So what he said, then he filed a petition. Okay, what is the background? Look, What is the right to be forgotten? Look into the black box first about the right to be forgotten, RTBF. It is the right to remove or erase or delete the content so that it's not accessible to the public at large. It empowers an individual to have an information in the form of news, video, or photographs deleted from the internet records. This actually originated from the French jurisprudence. Remember this. So if in case they ask what is the origin, so origin is the French jurisprudence. Again, the important thing which I want to discuss personally is this Puttoswamy case. Yesterday also, while talking about the other verdict of 2016, when I was discussing about this UIDAI. So in case Puttoswamy versus Union of India 2017, which is 9-judge bench, referred to as European Union Regulation of 2016, which recognized the right to be forgotten as a individual right. Then right to be forgotten is also right to privacy under right to life. Okay, right to privacy, as I have said, is a fundamental right. Remember this. And this is again very important. I think there will be a question on this also. This is, I'm doing a star mark. Center to overhaul IPC, CRPC, and Evidence Act. This is very important. So the Prime Minister in his address on 15th August 2022 had kept Punch Pran 5 woes in front of the people of this country. Goal of develop India, removal of colonial mindset, take pride in our roots, unity and sense of duty. These are 5 or Punch Pran, that is Punch or 5 vows. So the 3 things which I am interested is Bharatiya Nyaya Sanhita Bill, BNS, which will replace the IPC. Okay. Then Bharatiya Nagrik Suraksha Sanhita Bill, BNSS, which will replace CRPC. And Bharatiya Saksha, the Saksha means evidence. Okay. Bharatiya Saksha Bill, Indian Evidence Act. So these 3 acts, IPC, CRPC, and evidence, IPC, CRPC, and evidence will be replaced by BNS, BNSS, and BS. So this is the background. Okay. Look, the Ministry of Home Affairs in 2020 constituted a national level committee for the reforms in criminal law, headed by who? Ranbir Singh. Not a name of actor. Okay, it's Dr. Ranbir Singh. So remember that. And again, a national law university where you are aspiring to go into National Law University Delhi. Okay, and actually NLU is not covered under, I think, CLAT. NLU Delhi has All India, yes, elite exam, you know that. So people, those who prepare for the CLAT also prepare for the elite. And I think IELTS is much difficult than the CLAT. The reason is that CLAT has more number of seats vis-a-vis the IELTS. Okay. Again, Chandrayaan 3, very famous. I have just sorted and taken some important news articles. Okay. So I will not discuss much into detail, but the articles which are important, the events which were very landmark in the history of India, I have taken that only. The Chandrayaan 3 is follow-on mission to Chandrayaan 2 to demonstrate end-to-end capability in safe handling and proving the lunar means related to moon. Okay. Chandrayaan 3 has made history by becoming the first mission to soft land on the moon's south pole. Remember this. We are the first. And now India joins the club of whom? Of United States, of Russia, and of China. So we have become the 4th country to land successfully on moon. So it's very acclaimed mission for us. So mission took off from the Satish Dhawan Space Center, SDSC, Sriharikota, on July 14, 2023. and it has three things which are indigenously developed. It means indigenously means it has been of Indian origin. They are not bought from someone from some other foreign country. We have created our own infrastructure. What is that? Lander module, propulsion module, rover. Okay. What is the objective? Objective is to develop and demonstrate new technology for interplanetary missions. Okay. So that's it for today's lecture. I think for tomorrow, okay, I will look into what is the meaning by fabricated FIR, vanilla. Sir, we saw about Puttoswamy case yesterday. Okay, so what is fabricated FIR? Actually, FIR means first information report. Most of the times, what happens? People have jealousy. Let us say two brothers are fighting for land. So obviously they have jealousy, and they will try to do damage one another. So they can do what we can say a fabricated affair. It means you said to remember about women reservation bill. Okay, okay. Yes, I will also discuss about this women reservation bill. I will discuss that definitely. I think my screen is visible. The what can say women reservation. For us, this article from United Nations Women is important. That's what I wanted to discuss. This article. Okay. I think this article they can ask about women reservation. This is why I'm discussing this. Actually, it is not from any newspaper or any other magazine. It is from United Nations website. So that is the reason we are directly jumping to the website, and it is very recent one. It is article of October 4th. It's very recent. Last month only they have featured. India passes a law to reserve seats for women legislature. So I think this kind of passages they will ask. Okay. So look how they have framed the passage. On September 21, Indian legislature passed the first legislation considered in the country's new parliament building, the parliament building, the triangular parliament building which we have seen. The Women's Reservation Bill 2020. The bill which passed by both the houses of the parliament will ensure how much 33% seats in the state legislative assembly and Lok Sabha also. Rajya Sabha is not there. Remember again. Okay. So don't get confused. It is only assemblies. And the word is not council. Okay. The council and Rajya Sabha is still out of ambit. Typically, a critical mass of 30% representation by women in parliament is known to yield positive outcomes. Okay, that is what general observation is. If you have 30% seats, 30% representation in women, so it yields you results. So now you have the government is typically trying more than 30%. It's almost 33%. So it will obviously have more reservation. Forget about India. If you take example of America for that matter, in America till date, no, in 300 years, okay, since 1776, there has not been a single women president. They are taking more, and in India we had Indira Gandhi as a prime minister. So, and also they took 300 years to have the black president also, and they gave us lecture about the human rights. So if you look, our country is progressing much faster. We are getting egalitarian day by day. So it is very positive in that, and even in for that matter adult franchisee. Most of the countries didn't permit women even to vote, even though they were democratic countries. Right to vote was given to women very late, but we are the country who has given right to vote immediately after our independence in 1947. in the first election of 1950s, 52. At the time of bill's passage, 14% of Lok Sabha legislatures were women. How many legislatures are there? 14%. Now significantly it will increase to 33% after the next general election. So it will, it will have good time for women MPs and MLAs also. Among the state legislative assembly, Chhattisgarh has the highest level of women legislature, and that highest is only 18%. Okay, the the new legislation requires that just a minute. Just a minute. Just a minute. Hmm. Mute करो इसको. बंद करो. जूम में जाओ. सेकंड में देखो स्प्लिट हो गए. एक उस पे चौथे पे स्प्लिट हो गए. मीटिंग बंद कर पूरी बड़ी कर.